Well, I think we're pretty close to starting time, so we might as well get this started off. I'm Tom Nichols, and we've got bios here too. Caleb is, I'm in the tax and corporate area. Caleb is, we're very happy to get him. He worked at the Supreme Court, clerked at the Supreme Court. He's in the litigation area, so we'll kind of take team on the various things. Just, this is really just kind of intended to be just kind of an update. Okay, here's what's going on now. We're obviously not going to cover a great deal of detail. On the other hand, I'm kind of hoping that it'll be a good checklist for you to think, oh, maybe I have to follow up on this or that or whatever. So with that, I think we'll go back and forth a little bit, but we'll start with Caleb. Fire away.
And I'll say at the outset, if anybody has questions along the way, feel free to just raise your hand, shout them, get our attention. One of the issues of the day that I'm going to kick it off with is tariffs. Now, if you want to know exactly what tariff applies at what country and what you have to do to comply with, I'm going to send you over Tom's way. But I'm a litigator, so I've been following the litigation that has been going on, challenging the validity of the tariffs that the Trump administration has put into place. And so I want to tell you where we're at in that litigation, and then discuss a little bit where things could go from here, you know, with the assumption this is ultimately going to end up at the U.S. Supreme Court. Generally speaking, there have been 2 rounds of tariffs that have been adjusted a bunch of times. There's what I'll dub the trafficking tariffs, which President Trump instituted on Inauguration Day. And then there are the worldwide tariffs that President Trump implemented on April 2nd, which he dubbed Liberation Day. Both of these sets of tariffs were challenged simultaneously in at least a pair of cases that we're going to discuss here. And just in the last week, we got decisions from 2 courts, both of which struck down and temporarily paused the Trump tariffs in their entirety. Those decisions have been stayed, but we'll dive into those a little bit here. What may be surprising, if you've picked up the Wall Street Journal, is that the U.S. Constitution vests the power to lay and collect taxes, duties, imports, and excises to Congress explicitly, not to the executive. However, Congress, through a number of enactments, but most importantly here, has the International Emergency Economic Powers Act of 1977, IEPA, has delegated its power to regulate international commerce to the president when certain circumstances are at issue or are involved. So, national emergencies specifically here. Now, there's 2 decisions. I'm going to start with one that's actually not in the written materials, and this is a decision we got from the District of Columbia District Court, the Federal District Court for D.C. Last week. And what that case held was IEPA does not authorize tariffs at all. Now, I have some questions about that decision because IEPA authorizes the president to, quote, regulate importation. They went through some gymnastics. I mean, IEPA doesn't say tariffs, so they have a point. But they went through some statutory construction to conclude that regulate importation does not encompass tariffs. That decision's there. It's going to go to the DC Circuit. I'm not going to discuss it as much here, though, because the relief granted in that case only applied to the parties that brought that case. The other case is the case that is in the Court of International Trade. And this one matters a little bit more because this court granted a universal injunction pausing the tariffs. And what that court said, in essence, is IEPA does permit tariffs in certain circumstances. However, the specific circumstances in which IEEPA authorizes tariffs are not present here. There were a couple different bits of that, one of which was the language of the statute requires that the tariffs directly remedy or be aimed at addressing a particular security risk or national emergency problem. And they said, well, this is not that. This is simply because the president's concerned about the trade deficit, which is, not in itself a national emergency. But 50-page or so decision went up to the Federal Circuit, which is a U.S. Court of Appeals that handles appeals from particular courts, including the Court of International Trade. And the news headline after it got to the Federal Circuit was, Federal Circuit stays the Court of International Trade decision. And that's true, it did, but it was just an administrative stay. So which is just a temporary pause that a court issues to basically say, give us a second to take a look at what's going on here, and then we'll make a decision on whether you get a stay pending appeal. That decision is likely to come sometime in mid-July, and that'll set the stage, I think, for this case to go to the U.S. Supreme Court on the stay question. The Supreme Court has taken a number of these controversial cases at this early procedure, and my guess is that they'll be inclined to do so again here. Once the case gets there, I'm a little dubious, as I suggested earlier, that the court is going to buy the statutory interpretation of the lower courts in the cases that I just described. However, a number of scholars, including Jack Goldsmith at Harvard, have suggested the court may be interested in using this case to be the next step in the major questions doctrine. And this is essentially a doctrine that says when Congress uses broad language, we don't expect that broad language to contain really, well, let me put it this way. When Congress uses specific language, we don't expect them to be hiding elephants in mouse holes. We don't expect them to create really broad powers accidentally. It's not the most artfully put explanation of the major questions doctrine, but I think if the U.S. Supreme Court is going to press pause on the Trump administration's tariffs, it will be on that basis. And there's some precedent for it. This is the same thing that was used when President Biden issued the vaccine mandates. The court invoked this doctrine to press pause on that. And I can see a similar analysis playing out here, but it'll be a wait and see.
Well, it will, if you're thinking that this is going to be the end, the Supreme Court is going to rule against the administration, that's going to be the end of tariffs. I'm not sure whether you want it to or not, but it won't be. There's a 1962 Trade Act, there's a 1974 Trade Act, and there are a number of provisions that, notwithstanding the Constitution, that Congress has essentially specifically authorized the president to take steps in connection with tariffs. And we've seen, if there's an argument, they're making it, and they will take positions, and even if they're stretchy positions, they'll take it. So I don't think you can say that this case is going to be the end of the day. I think it's going to be part of the fight. And I took my economics course when both sides of the political spectrum thought that tariffs were not a good deal. So as a consequence, and I think there are an awful lot of businesses that are getting hit with tariffs that are, very much hoping that this case is going to eliminate it. I just don't think I don't think you can count on that. I think it's going to be an ongoing. unless we start to get actual agreements with the other countries that people are not trying to upset and challenge, et cetera, et cetera. That's obviously, we don't know yet. It's safe to say. So, I think I do the next. Are you done with this section?
Yeah, that's all on tariffs, unless there are any questions before we move on. Seeing none, we'll save them all for you, Tom.
All right, yeah, and certainly feel free to jump in with questions. What I've got, Caleb did a better job putting in text in his, and I have the big, beautiful act. Well, we've got the bill that was passed by the House. What do they call it? They literally have in the text of the act, it says one big, beautiful bill act. So it's been called that. It's also been called, actually I think this morning, a disgusting abomination. And all I've done is talk about the Republicans. Because Elon Musk is the one that's calling it a disgusting abomination. So there's obviously a range of opinions. A lot of this I think is very likely to be enacted. This one, unlike the tariff stuff, where I think there are questions as to whether or not you can, there are questions as to whether or not it's smart to do so, whether or not it's going to be superseded by agreements and all of that. I think this bill, you need to start to be planning for it, because a lot of this stuff is going to be effective next year. If it doesn't, and one of the reasons I feel that way is if it doesn't get enacted, there are going to be substantial tax increases, and nobody wants to be responsible for that. Right? The Democrats would love to have the Republicans be responsible for it, but the Democrats won't be responsible for it. And the Republican Party just doesn't want to be in a position where there's substantial tax cuts, and they haven't done anything about it. So I think a bill will be passed. The biggest provision in the bill that I think is going to impact closely held business is the 199 Cap A deduction. That's the deduction that allows pass-through businesses, S corporations, partnerships, sole proprietorships, allows them to take a 20% deduction when they're calculating the tax. So if the top tax rate is 37%, your top federal tax rate is 29.6%. That's a big deal. I know we were active in the S Corporation Association, and we were active in getting 199 Cap A enacted. I'm not proud of its design, but the big issue behind 199 Cap A was to allow closely held businesses to continue to conduct their business in a single tax system. Essentially, if you had a 21% rate inside of C corporations and you had a 37% or a 39.6% rate outside of C corporations, almost all closely held businesses, or at least the profitable ones, would end up probably switching to C Corp status. And I've been on the ABA Tax Section S Corporation Committee since the Tax Reform Act of 1986. I was only 12 years old when I joined it. But in 1986, they moved the top tax rates, so that used to be the C corporation rate was dramatically lower than the top tax rates for the individuals. And in 1986, they moved the top tax rate so that actually the individual rate was lower. That didn't last very long. But we moved, in terms of our closely held business clients, we moved virtually our entire client base from C corporation status to S corporation status. And especially when you're talking about selling a business, the difference when you're selling a business, even with the 199 Cap A, and the difference when you're selling a business is easily 20%. If you've got a pass-through business or you've got a C corp, you easily might end up taking 20% less after tax if you're selling through a C corp, because you got a double tax system, you got to pay tax both levels. The buyer wants to get a stepped-up in basis so they can depreciate and amortize all of these assets. So if there's any chance chance that you're going to sell. The large majority of closely held businesses want to be in a position where they've got a pass-through business. So the point of 199 Cap A, frankly, was we didn't want to force all closely held business into C corporation status. And essentially, I literally saw people before. I was 11 years old at the time, but my clients would be coming in and saying that, well, I've got this tax shelter here. The IRS is coming in. They're auditing my boat expenses. Everybody lived out of their C corp because they didn't want to pay that second tax. Closely held business. For publicly held business, it makes a difference whose checking account it is. If it's the publicly held business, that checking account is owned by other people. But if you've got a closely held business that's owned by one person or 3 or 4 or 10 people, they don't consider that money inside the corp not to be their money. And so as a consequence, before the Tax Reform Act of 1986, I had houses, didn't have a lot of trains, but we had plenty of boats and planes. And people were always trying to, they wanted to get as much personal expense inside that company. And I literally saw all of that stuff. I had one client say to me, so that's all I'm going to have to pay? So I don't have to talk to you? Just give me what the rate is that I need to budget for, and I'll see you next year. I literally saw a sea change in people's behavior with a single tax system. It worked so much better for a closely held, and that's why when the Tax Reform Act was enacted, it was like 15% of corporations were S corporations. Not in recent statistics, it's like 70%. Virtually closely held business, they just moved, and that doesn't even take into account partnerships, which are also pass-through businesses. So essentially, the single tax system, well, I do have bias, but the single tax system works much better for people that own their own closely held business. It just does.
And the Big Beautiful Bill puts that in jeopardy, or what is the Big Beautiful Bill?
Well, the Big Beautiful Bill, the Big Beautiful Bill does two things. This is an important point of the Big Beautiful Bill, just because it's so fundamental to the closely held business. But it does two things: one good, one bad. If you're a fan of closely held or pass-through businesses, one is that they move at least for now, they move the top rate from 20%, or the deduction from 20% up to 23%. And that essentially is a 1% tax bracket, because it's the deduction, and then the rate is, the top rate is close to a third, so it's about a 1% reduction in tax. The other thing that the bill did, and actually the language didn't work to begin with, but now it works a little better. The other thing that they did is they took the entity level tax, they allowed under a number of statutes, and I was involved in that too, but under a number of statutes that were enacted after the Tax Cuts and Jobs Act, states, and Wisconsin was the first, and I was very much involved in that, but Wisconsin was the first one to adopt an elective statute. Connecticut had a mandatory statute. But Wisconsin adopted an elective statute that allowed the entity to pay the tax instead of at the individual level. And the big difference there is if the entity pays the tax, that tax is deductible without limit. That's huge. That's for a top bracket taxpayer, that's an extra 1% to 2%. So that was a big deal. What the Big Beautiful Bill does is it says you can have it continue to do the entity level taxes, and that's what the initial Trump administration did definitely come out and say you can't, the entity level tax arrangement works. The Big Beautiful Bill says, yes, you can do that, but not for specified services, trades, or business. And so if you're in accounting, law, all of those various, it's all of those things that are not as favored in Section 199 Cap A, essentially, those entity level tax things don't work. And there's also, and this is something we're working actively also talking, the provisions right now talk about, in order to qualify to deduct those taxes at the entity level, you aggregate all of the businesses together and you've got to have at least 75% of your gross receipts from qualifying businesses, not specified service trades or businesses. And what I pointed out, and that is you essentially, so I've got a business that has $100 million of, or let's say it's got $10 million of income. And I've got, and 76% of that is qualifying income. I'm going to qualify for a 2% savings rate, 1 to 2% savings rate on that 76% that qualifies. But if that 75% rule stays in place, and my income, my gross receipts flip a little bit, and now it's only 74%, I'm going to have literally a 1 to 2% increase in all of my income, not just the specified service trades or business, all of my income. So we're hoping to try to get that provision out. I am sensitive about time. On the other hand, this is probably the most important thing that's pending at this point. But I've got a listing of what of things that I thought were worth highlighting to closely held business. We've talked about, well, obviously extending the rates, which are, the top rate would revert back to 39.6 instead of 37%. That's not nothing. We talked about the income deduction, increased estate tax exemption. If Congress doesn't do anything, the estate tax exemption right now per person is $14 million. If they don't do anything, that drops to $7 million, I'm rounding, down to $7 million. Well, that's a big deal. I mean, there are a lot of businesses, there are a lot of owners of businesses that have a business that's worth somewhere between $14 million and $28 million, and so as a consequence. Now, I think that one is very likely to be passed and included in the final bill. I think that's kind of thought to be important, really, at least of all of the Republicans, and frankly, most of them. Yeah.
When you and others say made permanent, how does it get unpermanent in the future? You know,
Well,
you know what I'm saying?
there are two different, because of reconciliation, and I don't know how familiar people are, but under the reconciliation rules, you can't have a budget deficit after the 10-year budget window, which is why we have so many of these that automatically expire before the budget window. Because, otherwise, you have to get 60 votes in the Senate instead of 50, and getting 50 is tough enough. So when I say they're permanent, they're not permanent like we couldn't change them, but it's a dynamic that is pretty important because clearly Congress can change them, but in order to change them, you've got to have the House and the Senate and the President all sign off on it. But if it's a permanent change, in order to change it, you need the House and the Senate and the President to sign off on it. And so as a consequence, and like for example, there's been a little talk about changing the 21% C corporation rate, but since it's permanent, that stuff didn't go very far. But that's because it's permanent, and they weren't going to get all three, President and the others, to go along with it. But that's the difference between, but it's not permanent in the sense that they can never change it, but it's, and
so are we going to be back in the exact same spot? Suppose this passes. Is it going to be the same thing again in 10 years?
Actually, it might not be. And it might not be because they're switching to a different budgeting mechanism. What they used to have is I'm pretty sure these are going to be the terms that you'll recognize. They used to have a current law budgeting calculation. And the current law would say that, like, if all of these things, the state tax exemption is being cut in half, 199 cap A would be repealed, all of these things, and all of the changes that were brought about that were what I'm referring to as temporary, all of those changes would automatically be treated as revenue costs if you made them permanent. That's the current law test, so that these are big numbers. $2.7 trillion is at least one of the estimates, and they're all right around there. So that the current law test would mean that you would essentially have to, you couldn't do much past 10 years, because under current law, when you extend the estate tax exemption increase, when you extend 199 Cap A, you extend the lower brackets, and the brackets are changed all the way through the brackets. I mean, even the $50,000 person is in the standard deduction. All of that stuff, you can't get that enacted because you're not going to have the Democrats go along with the whole bill. You can't get it enacted under the current law test, because there's no way in the world you're going to make up that revenue. But what they're trying, and this is coming mostly from the Senate, they want to switch to a current policy test, which means that 199 Cap A, yes, it's about to expire, but today it hasn't expired. And so that doesn't really cost us anything. That's just extending current policy. That's what the Senate is pushing for, and that's, frankly, I have a feeling that's going to end up carrying the day. So as a consequence, a lot of these things that are currently in policy, even though they're about to expire, will probably be extended and even outside the 10-year window. So we might or might not. There are things that are listed here that are like the No Tax on Tips Act and a couple of others, and the expensing provisions and things like that will disappear even under the big beautiful bill. They will disappear shortly after Trump leaves office, and so that will be, we will have some of that, but it won't, the big stuff, they're trying very hard to make that stuff permanent using this current policy. I'm not sure strategically, even for the fiscal hawks, that's a good step, only because, that's going to be flipped on when the Democrats are in a position. Then they're going to take current policy, but they'll take current policy not with lower taxes, they'll take current policy with current expensing. And, if the budget right now, under the 10 years, is at this level, and it's going to be going down to this level, they'll say, well, that's current policy, we're just going to continue that. So, I'm not sure current policy is a good long-term strategic maneuver, but they are using it, and I think they will use it, and I think that's going to be the new, going forward, that's going to be where we are. So I don't think we'll might not have the same cliff that we have now. That was a long-winded answer to your question. I'm done now.
Good.
I have a quick question, kind of side question, I guess. How do you think that the big beautiful bill will impact like how states change their tax laws? And Wisconsin doesn't always agree with everything on the federal side, so is there crossover that the states are going to wait and change stuff or not?
The states, for the most part, never adopted 199 Cap A. It's just a federal thing, and I think that's likely to continue. Several of the states, including Wisconsin, there are at least bills to, like the No Tax on Tips Act.
Right.
So I think they're going to adopt at least some of the stuff. There doesn't seem to be quite the federal-state divide in terms of policy that you sometimes see. The one big thing, which is also in here too, is the state tax deduction. Right now there's a cap of $10,000, and the big beautiful bill that was passed by the Rules Committee and passed by the House, I think it's like $50,400 is what's deductible, but then that phases out at $500,440 or something. But that's a dramatic increase, and that's an extra 30 grand or so that people would be entitled to deduct for state taxes, which of course is a big deal at the state level. So I'm taking it a little too long, or maybe way too long. The others, if you want to maybe spin through them, there's a listing there. Expensing is a big deal. Bonus depreciation, all of that. The 179 limits are going up. research and experimental. So a lot of the things that are there will continue. There's, in my opinion, there's some provisions in there that are problematic. 461L, which is essentially caps your trade or business losses at $500,000. I won't launch into my reason for why I don't think that's good policy, but there's a lot going on in this bill, and I think you kind of have to at least keep track of what's going on now. And the problem, they are planning on, they're still talking about getting it passed, and maybe even to the president's desk by July 4. But the most recent comment I've heard now is that, well, they'll get the Senate bill passed, and then they'd have to have a conference committee. So I'm not sure the July 4 deadline is a hard deadline. But I think they're probably, they really want to get this done in the summer. And that means, and then if I were you, that's when you really, once it's final, I mean, going through all of the details at this point, it's useful to know it's coming because it may have an impact on you. But I think you don't really want to spend too much time getting up to speed on it unless you're trying to help something at the federal level and trying to change something. But as soon as the bill is passed, there's going to be enough in here that frankly, it's going to be incumbent on all of you to have you or your accountant or go through and figure out, okay, what of the 150 provisions that are in here, which 5 or 10 of them are pretty critical to me and I need to take them into account. And I tried to pull out kind of a listing here. I'm not sure that's necessarily what would affect you guys, but that's kind of where we are now. So I will shut up and go back to Caleb.
One other quick question.
Oh, go ahead.
Where is the salt cap discussions that you guys have sense about that?
What is the salt cap discussion?
Yeah, where does that sit?
Oh, that's, unless the Senate does something to change it, I think the salt cap discussion is over. And the reason I say that is because there, as you know, there was a lot of back and forth. You know, it was 10,000, and they wanted it to be, I think at one point it was supposed to be 100,000 and even more. They wanted it off. They wanted, there was a lot of back and forth. And way at the tail end, and then it was, the initial House bill was at 30,000, and then they finally moved that up to 40,000. And then frankly, President Trump intervened directly and essentially said, you guys aren't getting any more. And that is, I think there's so much dynamics going in both directions. I don't think anybody wants to open that up again. So I think that $40,000 in the phase out, it could change, but it's as likely to go down as it is to go up. Because there are certainly, when you look at the Senate is Texas, Florida heavy. Well, they don't even have an income tax. So the idea of making it easier for people in the blue states and the borders and the coasts to deduct state income tax is not high on their list. So I mean, it could come down, but right now I would guess that it wouldn't, only because they've got so much to do. They just don't want to reopen that can of worms.
We're going to take a hard left turn for the next chunk here. We're scaling. We started with the federal level. We're going to focus on Wisconsin for just a second. And my goal for this segment was to pull out a few cases that the Wisconsin courts have decided in the last few years that are really worth noting. And what I landed on were 3 employment cases, and I have write-ups of those in the materials for you. But I'll briefly go over them here. And the one that's hot off the presses is the Oconomowoc Area School District v. CODA decision, which came out in the last month or so. And this has to do with arrest record discrimination. Under the Wisconsin Fair Employment Act, unlike the federal analogs, Wisconsin forbids employers from making adverse employment decisions based on an arrest record. An arrest record is defined really broadly. It includes, well, arrests, convictions, but it also includes knowledge that an employee interacted with the police or is being investigated for the commission of a crime or some other offense. Really, any sort of interaction that an individual can have with law enforcement falls within the definition of an arrest record. And under the Wisconsin Fair Employment Act, employers cannot discriminate on that basis. There's some exceptions for if the arrest record is substantially related to their job functions that aren't relevant for this case. The reason I pulled out this case, though, is because the Oconomowoc Area School District terminated a couple of grounds crew workers because they were stealing from the Oconomowoc Area School District. And the conclusion that the Supreme Court came to was that the school district had unlawfully discriminated based on an arrest record. And the reason this happened, and I think everybody, there's a statute and they're trying to make sense of it, but what the Oconomowoc Area School District did is they conducted an investigation into these two employees. And the investigation was inconclusive. They figured out $5,000 didn't make it into the district's coffers, but they couldn't say for sure who it was. So they turned the investigation over to the police. The police had the case for a year or so, ultimately cited these two employees for municipal theft. And at that point, the district came back and they had temporarily suspended the employees, came back and then reinstated them. But said, all right, now that we know that you actually did it because you have this municipal theft citation, we're terminating you. The employees sue, goes through a couple of levels of administrative review, gets into the courts. And the Supreme Court looks at the language of describing what arrest record discrimination is in the Fair Employment Act and concludes, yeah, you discriminated against these two employees based on their arrest records, and the statute doesn't have a restriction or a limitation on whether you in fact were the victim of the offense. It's a little messy. So what should employers do going forward? There's a defense, it's called the Onalaska defense, that says if you terminate an employee based on your own investigation, and only your own investigation, that's okay, even if there is an arrest record. You just have to very clearly show that you're terminating them for reasons other than the arrest record. Here the school district have basically said, yeah, you know, we saw the municipal theft citations and we thought that settled it, so we terminated them. That's not gonna fly. Now, I'm a little concerned this will dissuade employers from reporting crimes to the police because they don't want to potentially face liability. I think it's a messy, I see how the court got there, but it creates all sorts of messiness. But the takeaway for employers is to be very careful when law enforcement gets involved and you terminate the employee afterwards.
Be careful what you give for your reason.
I was just going to say, isn't a valid takeaway there that just to use the at-will clause that you don't specify a reason for termination? Or you just cite in general, we lost $5,000 that happened on your watch. I don't know who did it, but I'm cleaning house.
You can do that. It's easiest to do that when there's, I mean, what'll happen is once you get in front of the administrative agency, they're going to look at all the facts and ask, why did you terminate this person? And if all the evidence that they are presented with points to that, you terminated them because you're like, look, $5,000 is missing on your watch, then you're fine. But if they find an email that if in discovery you have to produce an email that says, hey, did you see that these folks had municipal citations? That's us.
Oh yeah, no, I'm saying do it way
Yeah.
before. Like,
Yes.
You can send it to the police all you want, but clean house now. Why
Well,
why
and-
do you even keep them on the table? I don't
If somebody's
know.
going to steal $5,000 from you, or you think they are, that's probably not the only thing in their personnel file. Make sure that you've got the other things, and maybe not even mention the thing that they got arrested for. Mention all of the other things, and that, I think, creates the record.
And my point is, you still have to be careful, because there's going to be a lot of discovery in all this stuff. Whatever documents that you have that relate to this is going to end up in front of the agency.
Yeah, the email that says, don't mention his arrest record, I'm sure that we can find something else in his personnel file. That, try not to have that.
That one's trouble. Hey, you all laugh. I see a lot of those emails. The two other cases, I know we're running short on time, so I'll just go over them briefly. The REITs case is about data privacy for employees. Aurora had a data breach that resulted in an employee having a fraudulent charge on her account. She brought a class action alleging a number of claims. Two important ones, one good news, one bad news, I guess, for employees. Now, the court said that an employee can have a negligence claim against the employer for negligently protecting or negligently failing to protect an employee's information, whether they're a current employee or a past employee. That's pretty standard stuff, and at this point, everyone, I think, knows that you have to take reasonable measures to protect data. If you don't, potentially on the hook for negligence. The other important thing that came out of that decision was the court said that Aurora could not be liable for invasion of privacy, which is a statutory claim. And that was important because that could have opened the door to attorney's fees and all sorts of additional remedies that could really make things tricky for employers. The last one, the Wingra Ready Mix case, is a case, and it's another Wisconsin Fair Employment Act case, but it has to do with accommodating disabilities. And everybody knows you have to make accommodation, you have to make reasonable accommodation for disabilities, particularly when an employee shows you documentation that they have a disability. This case says you have to make reasonable accommodations even if they don't give you any documentation, even if they haven't yet been diagnosed with any sort of disability. So here, it was a cement truck driver. He complained to his employer that the pedals of the truck were causing him back pain. Wingra had another cement truck they could have moved him to where he said that the pedals are a lot easier to operate, but they didn't, citing business reasons. At this point, there had been no indication, apart from the reported back pain, that this employee had a disability. There was no diagnosis, no doctor's note, nothing like that. And the Court of Appeals held, Wingra, you should have known that this person had this disability because he had complained of back pain and asked you for this accommodation. So that, there was a petition to take it to the Supreme Court, which was ultimately denied, so that is the law now.
I can give you in 2 sentences, update you on state taxes. Governor Evers and the Republican legislature are at it again. There's about $6 billion of unexpected, surplus. Governor Evers wants to spend it on all sorts of Department of Corrections and other, I'm sure, valid things that he wants to spend it on, and the Republicans want to spend it by reducing taxes, and they haven't decided yet, but they'll be back and forth and back and forth. And it's kind of interesting, unlike at the federal level, there's not as much, you can get a rough idea what's going on, but you can't, they're pretty closed mouth about their negotiations, so that I'm aware that the Department of Corrections is one of the things that Evers wants to spend on, but there's others. And as far as the Republicans, they're talking about maybe expanding the brackets and a couple of things like that, but unless they agree, essentially under the Wisconsin budget rule, Evers can take any comma or anything else and he used that little gambit by turning in, I think, what was supposed to be a 1-year extension, turned it into a 400-year extension by crossing off a comma or two. And so it was like, he's got a little more, he's got a little more to work with in terms of dealing with them, and so the Republican legislature, what they want to do is at least have some type of an agreement where, look, we'll give you this much, we get this much, but you got to sign it and not veto it. And that's, now we'll see if that works, but they're at it again.
Well, you heard the applause over there, you heard the applause over there, which means we are keeping you the longest, and the line at the bar is probably already quite long. But we appreciate all of you coming and listening to us ramble on about the law for a little bit. We'll stick around and chat with anyone who wants to, but thank you very much.